Okay, well, welcome everyone. This is our first podcast, and the first question we had is what should we call it? And we actually asked people, sent something out, and got all sorts of clever play on words or things about me or other things, um, which, from a staff perspective, a lot of them wanted to use some of those, but I determined at least in the beginning, we'll simplify it and we'll just call it the Hansen podcast. I rejected Sir Hugh because of humility. And that, as a working title anyway, in the near future, we're just going to say the Hansen podcast. We have as our first participant the Honorable Denny Chin from the Second Circuit. Um, Went to Princeton, then went to Fordham Law, was a managing editor of the Law Review. Then I think you went to Judge Worker,
Correct.
Southern
Southern
District.
District of New York.
And then you went as an assistant U.S. attorney.
No, first to Davis, Polk, and Wardwell, then to the U.S. Attorney's Office.
Okay. And how did you like Davis Polk?
I liked it a lot. I mean, it was a terrific experience for a young lawyer, but I knew that I wanted to do other things.
All right. Why did you become a USA in the Southern District?
Actually, when I was a 1L, my 1L summer, I was interning for Judge Worker, and I loved what I saw at the courthouse. I saw a bank robbery trial, and I thought, what a great job being an assistant U.S. attorney, and kind of decided I wanted to be an AUSA. I figured to be an AUSA, I probably would have to go to a big firm for a bit. I wanted to come back and be a law clerk, and I also wanted someday to come back and be a judge. So that was my plan.
You knew all this your first year of law school.
Yes, I loved what I saw, and um, I knew that's what I wanted to do.
Well, it's amazing actually that you got to do it all, right?
I got to do it all. I added one thing that I hadn't planned on, and that was some time at the Vladeck Waldman firm, a 40 lawyer labor and employment firm. I did that for a few years.
Okay, you left the U.S. Attorney's Office and you went into practice with two of your colleagues, which is not that unusual, actually, from the Southern District. And you were there about 4 years. What type of work were you doing then?
We were doing litigation, primarily civil litigation. The plan was to have a litigation boutique, and it was, three assistant U.S. attorneys starting their own firm. And so in the beginning, we took what we could get, but we had a pretty diverse practice. One of my partners had been chief of the immigration unit in the Southern District. The other had been chief of the environmental unit. And we did a variety of things, a lot of commercial litigation. But I also wound up doing some employment law. And so when we broke up, when our little firm broke up, um, I wound up going with the Vladeck firm.
Why did you break up?
Well, it was too much work, too little money. It was a lot of fun being on our own. Um, the hard part is getting business and getting the kind of business that was interesting, that would pay the bills. And we did okay, but for all the effort we were putting in, it was a little bit challenging. We all had young families, and so after about 4 years, we decided to move on to other things.
How did you choose this next firm?
Well, I had been doing some employment law. The Vladeck firm had been sending me a couple of some cases, and it was just a good fit. And when I started there, I in fact continued to have a little bit of my own practice, and I worked for the firm as of counsel. And after just a few months, we could see that it was a great fit. And Judy Vladeck, the great Judy Vladeck, asked me to come into the firm as a partner, and so I did.
And how long were you there?
About 3, 4 years, and then from there to the Southern District of New York in 1994. nominated by President Clinton.
And who was the U.S. attorney then?
When I was in the office,
Yeah.
I was hired by John Martin and served under John for about a year or so, and then Rudy Giuliani took over, and so the rest of my time I served under Rudy.
Big difference between the two.
They had different styles, that's for sure.
Oh, okay. And from there, where did you go?
From the U.S. Attorney's Office to our small
Oh,
firm,
that's right. Okay.
Campbell, Patrick, and Chin. From there to Vladeck Waldman.
Okay. Now, why did you leave that firm?
The Vladeck firm,
Yeah.
I got nominated to the bench.
And who nominated you?
President Clinton. I was recommended by Senator Moynihan. So Senator Moynihan had a screening panel, and I applied to that. This was something, as I noted, I had wanted to do for a long time from my first year in law school. And at the time, because of the politics, the shift to the new administration, there were 10 vacancies in the Southern District of New York. Mm-hmm. And there had also been a push for diversity on the bench. At the time, in the entire country, there were maybe 4 Asian American Article III judges. So I felt the time was right for me, and at the age of 39, I submitted my application for the Southern District of New York.
All right, diversity, how important is that in the federal judiciary?
Well, I think it's incredibly important, diversity in different respects, not just race and gender, but also diversity in backgrounds. It's helpful to have some colleagues on the circuit who have been trial judges. It's helpful to have some who have been academics. It's helpful to have some who have been prosecutors and some who were not. And it's also important on other levels, certainly from the public's perspective and the appearance of things. But beyond just appearances, I think the quality of justice is stronger if the bench better reflects society.
Yeah, I used to believe, growing up as in my household, a Roosevelt Democrat, then a Kennedy Democrat, which are actually quite different, that if you were paid enough attention and you had empathy and everything else, you really didn't need diversity because one person could understand other people's needs. And what I've since found, and I think is true, the old thing about unless you walk a mile in the moccasins, that expression, unless it's very difficult, I think, actually, to be the minority person who things are happening to is a very different experience than the sympathetic other person thinking about it. And so I'm actually glad that we are looking to do those things.
Well, there's an interesting study done a few years ago, and which was put into a Law Review article. The grants of summary judgment motions in employment discrimination cases. And the authors looked at the race of the judges. It was white judges and minority judges. And white judges granted summary judgment 60% of the time. Minority judges only granted summary judgment 38% of the time. I think that's a significant difference. You know, who knows why? I mean, one reason could be that minority judges find it more plausible that there is discrimination. And so I think that's a helpful example of how it could make a difference. I had a trial once where the defendants were, criminal case, defendants were Chinese. All the fact witnesses were Chinese. All the lawyers were white. The agents were white. And at one point, a witness is testifying and identified one of the defendants, and the lawyer stood up and conceded the identification, but it was the wrong person. It wasn't his client. And I think that sometimes it is just helpful to have that empathy, that that you should have otherwise, but quite often, of course, you have it more. You're more sensitive when you at least have shared some of the experiences.
Yeah, I think that's true. Uh, can you think of any case, and I don't have to mention any names of judges, that where you think because of your heritage, and actually we'll go back to Hong Kong a little bit because I'm interested in that beginning, made a difference in the how you ruled in the case? I don't mean a discrimination case. I can see where those situations would be, but just a regular case. Are you saying diversity actually has an impact there too?
I don't think that race is a factor in my deciding issues of law, for example. Um, in terms of trying to understand things, it can make a difference only in the sense that you may appreciate things that others might miss. Another example is in that same criminal case, a witness is testifying about what a victim said in an interview, and it comes out as extortion. And one of the questions I had was, with this victim who was uneducated, spoke only Chinese, was pretty illiterate. Was he using the word extortion, or what word was he using, and how was it being translated? These are just things to think about. Justice Sotomayor, when she was going through the confirmation process, talked about a wise Latina judge and a wise Caucasian judge, and who's gonna make a better or wiser decision. I think what's helpful is that the two of them together, by talking about it, by bringing their different perspectives, is helpful. There was a case a few years back where a search, a Fourth Amendment case, nothing to do with race, search of a 14-year-old girl, including removing her bra, that kind of a thing. Is it helpful to have a woman on the court who can appreciate better what that might mean than simply men? And this is before the Me Too movement. But I think having these different perspectives can shed light on things.
Yeah,
I mean, justice is blind, so why does the race of the judge really matter? And I think someday in a perfect world it won't matter. I just don't think we're there yet.
and one of the problems with this, the downside of this, is you're beginning to think that put people in boxes, and if you're from this background, you'll do this in this case or something else. And to give you one example, when I was a AUSA in the Southern District, I think it may have been my first trial, and there was a jury pool of which there was only one African American in the jury pool, and the person who was sitting in with me said, "Peremptory challenge, excuse that person." And I said, "Why?" And I said, "Well, there's a chance that the defendant was African American. There's just a chance that that's how the person's going to vote and be sympathetic, and it might have a hung jury." And I said, "Why? We can't tell that." And he said, "No, do it." And I said, "I refuse to do it." And so I did not excuse him peremptorily. He ended up being on the panel, and I think he saw that. Actually, the opposite of that is I had faith in him as an individual. I trusted him to make an accurate determination on the facts. And that sort of thing is actually very helpful, that we don't get into this putting people in boxes. And it turns out, of course, justice was served in that case, I might say. But I think sometimes I like diversity, but sometimes when we get too focused on it, we're going to actually not give that person or treat people fully as possible of doing all sorts of things.
Yeah, you don't want to get to the point where you are putting people in boxes. we've had cases over the years, including myself, where judges were challenged based on their race. In a famous case involving Constance Baker Motley, a New York City law firm, moved for her recusal in a employment discrimination case brought by a woman because Judge Motley was a woman, and you can't say that all women are unqualified to hear a gender discrimination case. And so, but these things are important.
Okay. Just in the faculty, we had an exercise where every faculty member, they were divided into threes, A, B, C, and the A person had to give 3 minutes on what were the major influences in their life, and then the B had to summarize that, and the C would try to see if their B missed some things or how we perceive things. Anyway, it was an interesting exercise. Everyone actually enjoyed it. Everyone particularly enjoyed that 3 minutes of thinking what were the influences in your life, because we rarely actually have to think about them and discuss them. But I'm going to ask you now, in no more than 3 minutes, what were the major influences in your life that you feel have affected you right up until now?
Are you asking about people, or are you asking about anything?
It can be people, it can be events, it could be anything.
Sure. Well, I think my upbringing as the son of two immigrants in New York City who did not speak English. We had very little money growing up. There were challenges and difficulties along the way, and I think that has impacted me and continues to impact me as I think about all of the challenges that my parents went through. Another influence would be Judge Worker, the judge I clerked for, as a young, beginning even as a law student and then as a young lawyer, and just watching him administer justice and run the courtroom and how he dealt with people in really one of my first real jobs. I think that was a huge influence.
Was he a mentor as well as?
He was. So I met him as a first-year law student, or that summer, and then I clerked for him for 2 years, and so he certainly was a mentor. Another great mentor, speaking of mentors and role models, is John Feerick. When I was a law student here, John was an adjunct, and I took employment law with him. And over the years, just got to know him, and he's just such a great person and a good person, and he's just someone you really want to emulate. There are other certainly.
Well, just saying a little bit of John Feerick, obviously, who was a dean here for many years,
Yeah.
and I have tremendous respect for. And in fact, his nickname was John the Good, which he
Yes.
hated, by the way. And he actually reminds me of you a little bit. He was beloved, and the two people that I probably know who you can legitimately say are beloved, John Feerick and Denny Chin. And so, what experience was as a student that you knew John?
I met him as a student in his employment class, equal employment law. And then over the years, as I became more active, and particularly after I became a judge, I interacted with him a lot more. It was at his suggestion that we started a minority mentorship program here. I remember when he was president of the city bar, I wrote him a letter and said there had never been an Asian American on the city bar judiciary committee. He put someone on. I sent him.
When was this? What were you doing when you wrote that letter?
I was active in the Asian American Bar Association. This would have been in the early 1990s, before I was a judge. I wrote him a letter. I suggested 3 names of people who might make good additions to the committee, and he put one on. And so for the first time, there was an Asian American on the city bar judiciary committee, that kind of thing. And then you just see what a humble and giving person he is, and so he is certainly someone I've wanted to try to emulate. I mean, there are lots of impacts and influences, and I don't know, it's hard to pick 3, but just being at Princeton, my family, I'm married. It'll be 40 years this summer, so there are lots of things. Good things in my life.
Wow, 40th anniversary.
Yes.
How are you about actually your anniversary? Do you
Well,
get flowers, go out to dinner? What are you doing those things?
dinner. When you've had 40, you don't do anything terribly special. This year we're going to take a trip. However, we're going to go to Scotland and look forward to that.
Why Scotland?
Just we've always wanted to be there, and just happened to pick it. And in fact, at your IP Institute, I had a conversation with a judge from Scotland, Ian Forrester, who gave us some tips
On what to see?
on what to see. Yes.
Yeah, Ian Forrester's a good man. It's interesting is that half of my family is originally from Scotland, and there's some view, and a lot of this country was actually populated by people from Scotland, maybe through Belfast coming in, and also the Irish directly. Um, but the people I know from Scotland, almost all of them are no longer in Scotland.
Hmm.
And Ian is a good example of that. He's been in Europe, he's been in the continent for most of his life. Yeah, but it's a great heritage. Uh,
My wife, by the way, actually has a little bit of Scottish blood in her. She's half Japanese, and her mother was a mixture of German, English, Irish, Scottish. So there's a little bit of Scot in her.
have you done one of these? I just got it as a present ancestry things.
Have not.
I'm gonna do that, and um, I'm interested in seeing. I have it. I know in my mother's family, both sides originally when Scotland came to Belfast and came over. But my grandfather, um, for various reasons, left the family at a very early age, and some people think my grandmother said, "Get out, never come back," and other people think he deserted the family. But he was Lithuanian, and actually, if he hadn't left, my name when Hansen was step grandfather, my father's stepfather. It would have been Hugh C. Viscaskis. Now, would my life have been different? I'm the same person, but if I was, instead of Hugh C. Hansen, Hugh C. Viscaskis, would I have had different life, different opportunities, different interests, or something else? What do you think?
Well, we'd be calling this the Viscasis podcast.
Yeah. By the way, that is named after my parents, not named after me. Okay. Maybe I'll do that. That'd be kind of neat. All right. Let's do a quick run through with the district court. Then I'm not very interested in your reenactments, which we could spend some time on. But so you were in the Southern District, and I just want to get some of the mechanics down. You, like Judge Worker, generally did not allow oral argument on motions in the district court. I had a judge when I clerked in the district court who always allowed oral arguments. Are there two sides to this, or is it what creates this?
Yeah, there are definitely two sides, and I don't know that one is better than the other. I was following Judge Worker's technique and not doing it. There came a time when I decided, let me try it. And for 10, 12 cases, I brought them all in for oral argument and try to rule on some of them from the bench. I mean, I think part of the theory is You might be able to save some work by hearing argument and then ruling from the bench if you can. Part of the theory also, of course, is to get more input from the lawyers and the back and forth, and I think that's useful. But I found when I did that little experiment that it was more work for me, less work for my law clerks, and I'm not sure it was of that much benefit to me. There were certainly times when I would have oral argument in the district court, including, for example, on preliminary injunction motions, things that were moving quickly. You'd want to have that give and take. Now, in the Second Circuit, our tradition is always to have oral argument with a couple of relatively minor exceptions. Many appellate courts around the country pick and choose what they will allow argument in. In our cases, unless you're incarcerated and pro se, or unless it's an asylum case, you don't have a right to argument. If you're pro se and you're not in jail, we'll let you have 5 minutes for oral argument.
How much do you give lawyers?
Most presiders, it's up to the presider, are allowing 10 minutes per side. In a complicated case, maybe 12 minutes or 15 minutes per side. When you pick and choose, the courts that pick and choose, they tend to give more time. But again, they're only hearing oral argument in a limited number of cases, and they tend to pick the ones that are more complicated. And so that's why we do what we do, 10 minutes in a typical case, but everyone who wants to argue can hear it. I get asked a lot, does oral argument make a difference? And frankly, in most cases, the answer is no. Most cases are fairly clear, and we're well prepared. We've read the briefs carefully, thought about it hard, and oral argument doesn't add that much. However, in the hard cases, in the close cases, oral argument is important. It can change our thinking, our reasoning, even if it doesn't change our mind on the bottom line. But it's a useful thing. I think if I were in the district court again, I probably would allow oral argument more often. But again, probably not in every case.
All right. Law clerks, district court, they're probably more important than in a court of appeals.
Yes, I think it's much harder clerking in the district court. A lot more to do, many different kinds of things to do. The volume is much greater. In the district court, they list your telephone number so that litigants and lawyers can call your chambers, and then the clerks would have to deal with that. In the Second Circuit, our numbers are not listed. If you want to call the Second Circuit, you call the clerk's office and you leave a message for Judge Chin. The law clerks basically have one thing to do, read briefs and either write a bench memo if I'm not presiding, or if I am presiding, write a bench memo or draft a summary order. The volume is much lower. There is more time between sittings, and so it's an easier pace. And I think overall it's less challenging. It's more like being on law review, glorified law review.
I clerked back in the day in the Southern District and the Second Circuit. And the Second Circuit had 2 clerks. And even with that, I was in the Judge Wine in the Southern District and Judge Gerfine in the Second Circuit. I found I had tremendous time in the Second Circuit, even then, with just 2 law clerks. And
now we have 4.
And now you have 4, and you don't even write an opinion and everything. We were writing opinions and everything. So it's, I say this, to some extent, being a Second Circuit law clerk is almost now a part-time job. No?
Well, I don't know if I would agree with that. It depends on the job. It certainly is a much less demanding job than
How about being a
court.
Second Circuit judge? Is that a part-time job?
No, it's not a part-time job. I've heard people say that before. It obviously is a lot less on your plate than the district court. particularly in the days when we were trying lots of cases. When there was a period of time when I was trying 20, 25 cases a year. And so in that sense, that was probably a job and a half or two jobs. And the circuit court is one job. I mean, that's another way of looking at it. The circuit court is more difficult in other ways, including that you have to work with others. You're not on your own anymore. In the district court, you are independent. You work at your own pace. You can write it the way you want it. In the circuit court, sometimes I sense that either I feel like I'm waiting on someone else, or I'm worried that someone else is waiting on me, because you've got to work together. And sometimes you want to come out a certain way based on certain reasoning, and the others disagree. And so that puts a limitation on what you can say. And in our circuit, the culture is to be unanimous as much as possible. And so
What's the reason for that?
I'm not sure. I mean, I think I've heard judges say sometimes we probably ought to dissent more, but I think it just makes it more collegial. I think it's a good thing in general, to decide cases on a narrow basis. And so if you try to be unanimous, you're more likely to be narrow, and that's a good thing, because you're not saying all these things that could come back to haunt you when you don't need to. It's also more challenging in that you do have to think more about the future and other cases, and what's going to happen with your ruling in this case, whereas in the district court, your decision is not binding on your colleagues, and you need to think a little bit about getting it right for the appeal.
Do you ever, if you have a really difficult case, send it around to the court generally? We're thinking of deciding this way, and does anyone have any comments if it's going to have dramatic impact?
We don't do that in general in the Second Circuit. I know in some circuits they do distribute draft opinions before filing. We have what's called a mini en banc process, and that is if you're issuing an opinion that cuts back on prior precedent. For example, if you want to say that a recent Supreme Court decision effectively overrules a Supreme Court precedent, you might want to send it around before you file to see what the other judges think. But in general, we don't circulate opinions to the court before we file. As you know, we have an en banc process. We don't go en banc very often. That's one thing it's hard to get used to in the circuit court, is that I can file an opinion today, and then my colleagues, even if they're not on the panel, can call for an en banc vote. And that is something that you don't have either in the district court.
But the Second Circuit is so rare that it's very rare to have a banc.
It's very rare to go en banc, but there are
I see.
There are votes fairly often. En banc votes are called for, and then we have this internal deliberation where we go back and forth. But because our culture is to resist in general, we don't go very often.
Well, a good example of that is the Ariel case, which you were on a panel you dissented from.
Yes.
And I don't know, one of the parties sought en banc, or a judge can seek en banc, or...
Yeah, my recollection is the parties did seek en banc in that case, but I actually called for a vote, which I don't do. I don't believe I've done it in any other case where I've called for an en banc vote. I did in that case because I felt the majority had gotten it wrong, and I felt the case was worthy of an en banc hearing. In part, the majority's decision relied heavily on Cablevision. I always felt Cablevision was wrongly decided. I happened to be the district judge in Cablevision who was reversed, but apart from that, I felt that Cablevision was wrongly decided, And I thought that going en banc would give us the opportunity to come to the right result in Aereo, and then possibly to go back and revisit Cablevision, which we could have done by going en banc.
Yeah. Well, the interesting thing about Cablevision, I don't want to go into the merits because a lot of people probably don't know about it, but it all goes back to lawyers, and this is IP owners, copyright owners, sometimes are their own worst enemies. I think Google Books is an example of copyright owners or Authors League or whatever who very strangely were arguing things that were actually going to hurt copyright owners, especially small copyright owners and publishers. But in Cablevision, because they did not want to offend consumers who were taking cable and say they're directly infringing through this DVR, they sued for direct infringement against Cablevision, of which it's not going to be direct infringement. It's contributory infringement. It's frankly a pretty easy case. And actually, Judge Walker in there said, if you were looking for contributory infringement, we might very well have gone there. So these strategic decisions sometimes can have drastic consequences. And Google Books is you're getting a lot of decisions which can be bad for copyright owners because the court's thinking, my God, if they think this is an infringement, we have to write it very strictly in fair use and other things to make sure it won't be. So what you end up is a worse opinion by actually challenging it.
Yeah, I have been hoping for double vindication in Aereo, hoping that when the Supreme Court took it, not only would they reverse the majority in Aereo, but they would go back and fix Cablevision. So I had to settle for single vindication only, as they didn't touch Cablevision.
Yeah, and that actually, the Aereo case, I think is interesting. It had two things. One is the judge who wrote it was very well respected in the Second Circuit, Judge Walker. I mean, it was chief judge and then no longer. And I think to some extent, there were some lawyers who felt in Aereo, we have to respect that decision. I don't actually think it covers it, but we have to respect it. And then the other view is it's such a waste of time to do this that we'll just let the Supreme Court correct it.
Yeah, I mean, that's a big part of our institutional meaning, the Second Circuit's resistance to en banc. If it's that important, let it go up to the Supreme Court, and the Supreme Court will fix it rather than spending another year in our court. When en banc review was denied in Aereo, I only got 2 votes. There were others who thought I was right, but their feeling was, why keep it at this level and go through a whole process again and take the time? Let it go up to the Supreme Court. In the end, they were correct.
Yeah. Let me see, what was that? Hold on. So after Aereo was decided and you were vindicated, did people on your court say, well done, we were wrong, you were right, or what?
There were a number of nice emails.
Good.
There's not a lot of gloating that goes on.
Yeah. Now, do you feel you don't dissent very often, right?
I've not dissented a lot, although recently I've been doing it a little bit more.
Now, I've noticed that, and I'm just wondering if Aereo broke a logjam in your mind, if I was able to actually achieve some good in that case, and maybe I should dissent more.
No, I don't think that was thinking on my part, at least not explicitly, maybe subconsciously, I don't know. I think that, in time, I've just become a little more comfortable, and I think I do appreciate that sometimes, not often, but sometimes it is worth expressing a view. Sometimes you can hurt things by dissenting. We do a lot of decisions by summary order. If you really press your point, if you're in the minority, then the majority has to write an opinion. And now you have a precedential opinion, and you have the satisfaction of writing a dissent. Whereas you might compromise and say, I'll go along if we do a summary order. So the summary order comes out the way that you don't like, but it's theoretically not precedential. And so you wait for another time, another case to press the issue.
There's another strategy in that, and some in the Supreme Court have taken this view, is if I dissent, I'm just telling the whole world what I want is absolutely wrong and highlighting it like on a billboard. So what sometimes they do is they'll write a concurrence in a judgment, which is de facto a dissent, and that can then be cited in the future.
Yeah.
Does that ever play out in the Second Circuit?
Oh, I think so. I mean, I think sometimes you can make it worse by dissenting, and sometimes you might be better off writing a concurrence or not pushing the issue and waiting for another day.
Okay, reenactments. How did this get started?
Well, in the last, I don't know, 12, 14 years, I've spent a lot of time doing reenactments, and these are reenactments of historic cases. I got started by being a member of the Federal Bar Council Inn of Court. And when I joined, the first program we did was the trial of Ethel Rosenberg. And it was a great experience. It was fascinating diving into it. We wound up getting transcripts of the trial, and I was able to find them in the National Archives on the original onion skin paper that some court reporter typed up in the 1950s. And the case raised issues that were still very important. Instead of a bomb, if you put in the word terrorism, you have the same kinds of issues. How does the justice system deal with these issues of national crisis in times of war, times of pressure? And then at one point, the Asian American Bar Association of New York wanted a program to put on, and I suggested the Rosenberg reenactment. We had a 55-minute script. That's just a terrific script.
Now, who wrote the script?
It was done by my team. The Inn of Court. Each team is headed by a judge, so it was a group effort. We reviewed the transcripts, did the research, and then put the script together. And in fact, in that first presentation, I played Julius Rosenberg. I picked that part because we were focusing on Ethel, and Julius had a very small part. But I had the death penalty imposed on me. And even though it was pretend, it was extremely uncomfortable. It was not fun. I sat at counsel table during the reenactment of the trial and the summation, and the lawyers would point fingers at me and call me names, about, you see this quite often, what an idiot this defendant is, that kind of a thing. But I got to say, it was really quite a good experience for me to be sitting at counsel table and being in the role of the defendant. But from there it went on. We decided to do an Asian American case. And
Hold on, before I get there, just a little historical note. The judge in that case was a Fordham graduate.
Yes.
Judge Kaufman, who later became
Second Circuit.
Second Circuit. And I don't know if you've heard this story, but it's been told to me many times by people at the time, is there was a vacancy in the Second Circuit, and the city bar, or people in the city bar, thought that he shouldn't be the judge. And they convinced Henry Friendly. And part of it is they didn't want it to be considered anti-Semitic because Judge Kaufman is Jewish, but Judge Friendly is as well. And they put him up, and he was actually put on the Second Circuit. Then Judge Kaufman went up later on. But it's interesting sometimes how these things work, isn't it? And if it's true, yeah. Judge Friendly has been a pretty fantastic judge, right?
Well, some would say he was, the best appellate judge of all time. Many would say that. There certainly was some resistance to Judge Kaufman because of the Rosenberg case. But eventually, as you know, he was appointed to the Second Circuit and eventually became chief judge. But during the course of putting together that program, I reviewed almost the entire trial transcript. And Judge Kaufman was really injecting himself. He was asking questions of Ethel Rosenberg, for example, that prompted her to invoke the fifth in front of the jury. That would not happen today. But, this is before some of the Supreme Court cases that were on point. But Judge Kaufman was very active and asked quite a few questions himself. In any event, we did at some point start doing Asian American cases. We've done 11 of them.
Well, they weren't all Asian American.
No, 11 were. I've done, I think, 24. Many were not. Many, I continue and still am a member of the Inn of Court. At some point, folks started asking us to do reenactments. For example, Judge Ann Williams of the Seventh Circuit asked us, my wife and I, to do a reenactment to celebrate Constance Baker Motley.
You need an agent.
Well, it's become that almost. And so my wife Kathy and I picked James Meredith, suing to integrate the University of Mississippi. And we did a fabulous reenactment of that trial.
James Meredith.
James Meredith, the preliminary injunction hearing in Mississippi in 1961. And this is 7 years after Brown versus Board of Education, but there still was tremendous resistance in the South to integration, including on the part of the judges. So you had some judges really resisting integration. On the other hand, you had the Fifth Circuit, four of the Fifth Circuit judges, including John Minor Wisdom, who really wanted to implement Brown and integrate the South, and they did a lot to do that. But you could see how, the judges could impact these important issues.
Well, actually, going back to our diversity thing, is James Meredith was a very interesting African American in that I think he may have even been racist himself against whites. He did his march, famous march. He didn't want any whites on it. He didn't want the groups that were actually civil rights groups having any part of his situation. It was just him. He actually, David Duke was running for governor in Louisiana. He supported him, and other racist Southern senator in Mississippi, he supported him. Is quite a character that you think of, you put somebody in a box and they jump right out of the box. And he had all these, as he said, independent views. I'm an independent person.
Yeah, I mean, he certainly wound up being a controversial person who took controversial issues. Our program focused on the early days when he wanted to integrate Ole Miss, and at one point he wrote a letter to Thurgood Marshall and asked for help, and Thurgood Marshall's solution was to send Constance Baker Motley down to represent him. And one of the interesting things is, here you have an African American woman, a lawyer, going into the Deep South to, butt heads against assistant attorney generals and judges who were resisting integration. There was a passage that we came across that when she was in court arguing the case, the courtroom would be filled with African Americans from the community who were just there to watch this black woman arguing the case. And there were just lots of really interesting things. At one point during the trial, the assistant attorney general was asking questions of a witness and pronounced the word Negro as Nigra, Nigra. Judge Motley stands up, objection. It's not pronounced Nigra, Nigra. It should be Negro, Negro. And the assistant attorney general said, I mean no disrespect, but this is the way I've been pronouncing the word all my life. And the trial judge overruled the objection and said, you can pronounce it the way you want. Really interesting things like that. And again, these are still issues that are important today. And that's why we've been drawn to these reenactments.
Interesting. Thurgood Marshall, to the very end, did not want to give up Negro, even when it was African American. And he continued to use the word Negro because he thought that was the appropriate word. So it's interesting. These things, which considered minor, actually are not all that minor to people.
Yeah. Another example is one of our reenactments is about draft resistors who were interned in the internment camps during World War II. We wound up using the term concentration camp. We gave this presentation one time, and during the Q&A, someone stood up, a teacher from the New York City public school system, who objected to our using the term concentration camp because he felt that this was something that should be reserved for the Holocaust. We had actually talked about this as we were preparing the program. We were actually using internment in the beginning. And a professor who had written the book on the Heart Mountain draft resistors suggested that we use the term concentration camp. In any event, it's another small example of how these things wound up generating some very interesting conversation.
And do you think professors should use your reenactments? I don't know if you've published them, the scripts or whatever, as teaching tools in their courses.
Absolutely. They're great teaching tools. Our reenactments have been represented all around the country. We've even done one in Switzerland. One of our reenactments about the murder of Denny Chin in Detroit in the early 1980s has been repeated more than 30 times, including by the Department of Justice.
So how do they get the script?
There are a couple of websites. The Second Circuit has adopted this, embraced this. On the Second Circuit website, Justice for All, there's a page for reenactments, and we've posted information about them. And the idea is a bar association, a high school, a college can request the script, and we will send it to them. There are also slides that accompany the script. The Asian American Bar Association likewise has a trial reenactments page devoted to this. And you can send in and make requests. Our reenactments have been done here at Fordham Law School, 4 of them. They've been done at Princeton. They've been done at Harvard.
Why not just post it and let anyone take it? Why do they have to ask permission to get it?
Well, we want to make sure that they're being done for an educational purpose. We want to keep track of who's using them. And so those are the reasons. The first 5 actually are published in a law review. The Asian American Bar
Well, because the reason I
Association.
ask, it'd be very interesting just to read, and you're denying the public that.
Well, the first 5 are of the Asian ones are in the Albany Law Review, and they're readily available. There are enough descriptions online so people can find out things about them. There are many of them have been recorded, and the videos are available online, so people can see them. But they are really a terrific teaching tool. 2 weeks ago at the Thurgood Marshall Courthouse, we were celebrating Law Day. We had 300 high school kids in the courthouse. They saw, among other things, a reenactment of the Susan B. Anthony trial. Susan B. Anthony was prosecuted in upstate New York for illegal voting. And so we did versions of our reenactment of the Susan B. Anthony case.
That's great. All right, we have very little time left.
Can I just mention one more? We did at some point, I didn't write it, I didn't help write it. The Connor Inn of Court did do an IP reenactment, and I thought you'd be interested in that, on the Wright versus Curtis patent litigation. Was argued in the Second Circuit in 1913. when the Second Circuit was still hearing patent appeals. In any event, it's a reenactment of the argument. It gets into the dispute between the Wright brothers and Curtis. It was put together by the Inn of Court named after the late Judge William Connor. And so there is a program. It was presented in 2016.
And the patent owners won.
Yes. They won the patent litigation, or though some say that they lost the overall battle.
Uh,
We're almost out of time.
we're almost out of time, but so finally, you've been a judge for how many years?
24 years.
Um,
16 as a trial judge, 8 as a circuit judge.
okay. Now, in terms of when you started to now, has the judicial system changed? Is it basically the same? If it's changed, how has it changed?
I mean, I think it's changed in some ways, although I think, the fundamentals are still the way they were. Like everything, technology, computers have changed things to some extent. The way briefs are filed and written and researched. In the Second Circuit, we are still, to some extent, exchanging voting memos and drafts by fax, believe it or not. But even that's starting to change.
Well, you're
a
doing
little bit.
fax basically, otherwise you're afraid they'll be stolen, right?
I think initially it was a security concern. At least that was the stated concern. I think part of it was just this is what the judges were used to. As more judges have been coming on, I think it's starting to change. Now we do both fax and email, but we're still sending it by fax. And these days, of course, the technology is so good that the faxes are at least clearer than in the old days when you used the old fax machines, it was hard to read it sometimes. But, I think the basics of making your arguments, writing a good brief, presenting a good oral argument, they're still very much the same. One of the fun things about doing these reenactments is going back and seeing how things were done. How we did one on the Wyatt Earp case. How was cross-examination, in the 1900s when cross-examination was being developed, that kind of a thing. And you'll see that, good advocacy, the basics are still the same.
All right. There's one complaint I hear sometimes from the bar is that the students coming out now can't write as good as they used to be able to coming out of law school. Do you see any truth to that?
I think there is some truth to that, and I would blame that on computers. I mean, I've been teaching legal writing here at Fordham for some 30 years, but I can see it with my kids. When you're texting and emailing, you wind up taking shortcuts all the time, and you become lackadaisical about grammar and how careful things are. I think when you're doing research simply by doing word searches, you're not as careful. You're not thinking as much anymore about the concepts and the rules and the principles. Instead, you're putting a few word combinations into the computer and hope that you get lucky to some extent. And so, I miss the books. We still have some books. But not many. Our library budget gets cut every year. But the ability to flip back and forth among the different pages to see what else there might be, those are useful things. Picking up a treatise or a hornbook and starting to try to understand some of the principles before you dive into the different word combinations, I think is also a useful thing. So I think there is some of that. We sound like cranky old people complaining about the new generation and moaning about the loss of the old days. But I do think that there probably is a little less deep thinking now.
Yeah, that's unfortunate. All right. I'm getting these looks from people here. Denny, thanks so much. This has been fantastic, and
You're very welcome. Good luck to the new endeavor.
thank you. And anyone who's listening, if you want to have questions about this, we could pass them on to Judge Chin. And if you have any suggestions as to what we should do in the future, or what the name should be, other than, of course, the semi-sacred Hansen podcast, we'd be happy to have them. And thanks again, Denny. It was great.
You're very welcome. Delighted to participate.
Thanks for listening to the very first episode of Non-Obvious. Make sure to subscribe to us on SoundCloud, Apple Podcasts, or Google Play, or visit our website at nonobviouspodcast.com. Stay tuned to hear a clip from our next episode when our guest will be former director of the U.S. Patent and Trademark Office, David Campos.
When the legislation passed, this was now the first, so everyone celebrates, right? Everyone backslapping. And then suddenly I can remember this. I woke up, I think we had a big White House party, president, pictures in the Oval Office. It was great.
You actually have the pen that.
Yeah, I got one of the pens. He
One
used
of the
several
pens,
pens, yeah. And that Saturday morning, the next morning, I woke up and it suddenly occurred to me, and I turned to my wife and go, you know what? Who the hell's going to actually implement this?